um, because, I mean, somebody died here, which is probably the worst part of it. But in terms of the facts, we really only have one side of the facts here. And that's the side of the facts of the individual who was driving the truck who ran over Kayla Ellingson. Um, we have some understanding of the facts from phone calls to his mother, from what we understand. But otherwise, it's really not settled in terms of what the facts are here. But the issue is, of course, whether he should have been released pre-trial. And it's an emotional issue. Obviously, you see somebody being released after something this inflammatory, and you wonder exactly why that happens. And in this case, it's the law. And the judge in this case, Judge Hovey, had no choice but to release him on pretrial because of North Dakota's rules, Rule 46 of the state rules of criminal procedure that require release if the person can be assured, if the court can be assured that the person will show up for future proceedings. And in essence, it's just respect for our innocent until proven guilty principles under criminal law, which we all want applied to us in the same situation.
Right. I think what's hard for people to stomach, and you and I had this conversation earlier, is because I asked you, so what do you see took place here, and you were sort of like, hey, look, we don't know. So everyone, I want to preface this with that, but you were like, he could have been in his car, felt like he was being threatened. He said this person was on the phone, but at the same point in time, he was in his car. This is a young man. So what if he's on his phone? Get in your car, either stay in your car, call the cops, or just drive another direction and get away from this person,
Right.
right? I think that's what's hard for people to realize is, look, I'm in my car. There's been no conversations about a weapon from this young man. He's on a phone. Okay, I can either drive away, get away, call the cops, but to choose to run him over and kill him. I mean, it wasn't like you just tried to scare him. I mean, you obviously hit him and killed him. I think people are concerned, hey, could he be a threat to somebody else if he got triggered that bad just from a political conversation? But you're saying doesn't matter according to North Dakota Century Code. Am I understanding you right?
Right. Yes. And there's the personal side of me and there's the legal side of me.
Right.
And the personal side of me was shocked by this as well. And that's why when we were discussing this earlier, I was speculating as to what possible facts could lead a person to feel there was a justification here at self-defense, for instance. And I don't know that those are the facts because I'm not quite familiar with all of the facts at this point in time. So I couldn't speculate on that. But Rule 46 of criminal procedure rules require that a person be released on recognizance or on a personal recognizance bond if the court can be assured that that person will show up for future court proceedings.
So even if there's a potential this person could be a threat to himself or others,
the court can put in place certain conditions in terms of probation or in terms of the bond that they're released on, and they can set bail if they feel that there's a risk to the community. But from what I saw, the facts were very bland in the documents that were filed. And so what the judge has to go on is what he's presented. And the judge can't go based upon speculation. He has to err on the side of pretrial release because that's a tradition in our judicial system. And there's Supreme Court opinions on that we really favor pretrial release, primarily because person's not convicted and we don't take away their liberty until there's actual conviction in place.
if you're just joining us, David Chapman is with us.